All right, so today we are taking a deep dive into something that sounds kind of dry, but is actually really important.
Oh, yeah, definitely.
We're talking about rules 23 through 29
Mm-hmm.
from the rules of civil procedure.
Oh, yeah.
And these are all about something called modes of discovery.
Right.
Now, if you've ever, if you're thinking about a civil case or maybe, something you see on TV,
Yeah.
You need to get information from the other side, like you're building a case.
Yeah, exactly. Yeah.
So these rules, they basically lay out how you do that. They're like your playbook.
I like that. That's a great analogy. Yeah, it's your playbook.
So the main source that we're looking at today is this document called 8/2024 Golden Notes Remedial Law 2.pdf.
Sounds good.
So to kick things off, I'm curious, like how crucial is this discovery process?
Oh, it's crucial. It really can make or break a case.
Okay.
Think of it this way. It's like when you're building a house,
Okay.
right? You can't just start putting bricks on top of each other.
You need a good foundation.
You need that solid foundation, and discovery is kind of like that. It's where you're gathering all the facts,
Oh, okay.
the evidence, like the building blocks for your case
Yeah.
before you even get to trial.
That's interesting. So it's like the prep work.
Yeah, exactly.
And one thing that I find fascinating is these rules, they apply to both sides.
Right,
So it's fair. It's not like one side has an advantage.
exactly. It really levels that playing field.
Oh, great.
And make sure that everything's, fair. And, it's not just for your typical lawsuit.
Oh,
We're talking special proceedings as well.
interesting.
So things like probate, guardianship, anytime there's that need for information gathering, legally speaking.
So it's pretty broad.
It is, yeah.
So let's talk about the specific ways you can gather this information.
Okay, sure.
What are like the tools in the toolbox here?
Yeah, so there are 5 main modes of discovery.
Yeah.
Depositions, interrogatories, requests for admission, production or inspection of documents and things. And then lastly, physical and mental examinations.
Wow, that's a lot to remember.
It is. To help remember, just think of the acronym D in Repudet.
Okay, D in Repudet.
Yeah.
Got it. All right, so let's unpack these one by one.
Okay.
Starting with deposition.
Okay, sure.
What exactly are we talking about here?
So think of a deposition as a preview
Oh, okay.
of a witness's testimony.
Interesting.
It happens before the trial even starts.
Okay,
And both sides can question the witness under oath,
gotcha.
get their statements on record.
So it's like getting a sneak peek
Yeah,
at what they might say in court.
exactly.
And that must be super valuable, right?
It is.
For just planning your strategy and everything.
It is. And, there are 2 types. So there's oral
Okay.
and there's also written.
All right. So when we're talking about depositions, are there any rules like when it comes to actually scheduling them and, like when you can actually take them?
There are. One thing to remember, when you're calculating deadlines, you have to exclude the day of the act that triggered the need for the deposition.
The day of the act.
Yeah, so let's say someone filed a lawsuit yesterday,
Right.
and that triggered the need for a deposition. When you calculate the deadline, you don't count today because that was the day of the act. You actually start counting tomorrow.
That makes sense. So you kind of get like a free day.
You do.
All right. Well, that's a good tip to know.
Yeah.
So let's say we've taken a deposition.
Okay.
When can we actually use that in court?
All right. So they can be used in a few different situations. So for example,
Yeah.
let's say a witness contradicts their earlier testimony,
Oh, interesting.
or if they become unavailable for trial.
Okay.
You can also use it if the person giving the deposition is a party to the case, or if they were, say, a company representative.
So there are some very specific rules.
There are.
It's not just a free-for-all. We can use it whenever.
It's not a free-for-all, no.
Now, what happens if someone tries to use a deposition, I don't know, unfairly, or if they're asking questions that are totally irrelevant?
Yeah, good question. So there are safeguards in place. So during a deposition, you can actually object
Oh,
if you feel the question is irrelevant.
right.
Or if it, say, calls for confidential information or is meant to harass the witness.
So it's not just, anyone can ask anything they want.
Right. And also, the court itself
Okay.
can issue what's called a protective order
Okay.
to prevent a deposition from happening or even limit what can be asked.
So it's like the court is kind of overseeing the process,
They are, yeah.
making sure everything is above board.
Exactly.
Now, I'm curious, like when you're actually conducting these depositions, What does it look like? Is it just, you and the other side in a room, or is there like a whole process to it?
No, so for an oral deposition, it's kind
Yeah.
of like a mini trial. There will be an officer who swears in the witness, make sure they're under oath.
Right.
They record the testimony, like word for word,
Wow.
and they also note any objections.
Okay.
And those objections are addressed by the court later.
So it's a very official proceeding.
It is, yeah.
Now, you mentioned written depositions before.
Yeah.
What's the difference between an oral one and a written one?
So for a written deposition, instead of that back and forth live questioning,
Right.
the questions are actually submitted in writing
Oh, okay.
beforehand.
So it's more like a formal interview, but on paper.
Exactly.
But I'm just thinking, the world's a big place.
It is, yeah.
What happens if you need to take a deposition from someone outside of the Philippines?
So in that case,
Okay.
we use what's called a commission.
Commission.
Yes. So basically, the Philippine court authorizes someone in that foreign country to conduct the deposition.
Oh, okay.
And sometimes that other country might need like a more formal request from the Philippine government.
Okay.
And in that case, we use what's called a letter rogatory.
The letter rogatory.
It's basically a diplomatic letter asking for assistance in gathering evidence.
So there's a whole international element to this,
It
too.
is, yeah.
Now, anything else about depositions that we should touch on before we move on?
One more thing. Sometimes you need leave of court to take a
A
deposition.
leave of court. What does that mean?
It's basically just permission from the judge.
Okay.
So, for example, if you want to take more than 10 depositions in a case,
Right.
you would need the court's approval.
So there are some limits in place.
There are, yeah.
Okay, great. So that's depositions.
Yeah.
Our first tool in the discovery toolkit. Let's move on to the next one. Interrogatories.
Okay.
What are those all about?
All right. So, interrogatories, they're all about getting detailed written answers
Okay.
straight from the other party. Think of it like a really specific,
All right.
legally binding questionnaire.
Oh,
It's a way to get those key facts on paper, which
Uh-huh.
is super helpful as you build your case.
so it's like a legal deep dive
It is.
into what the other side knows.
Exactly.
Okay, cool. Now, I'm thinking back to written depositions,
Yeah,
and they sound kind of similar.
they do.
So what's the difference between the two?
So, with interrogatories,
Okay.
you send the questions directly to the other party,
Uh-huh.
and they respond in writing without needing a court officer present.
Gotcha.
Depositions upon written interrogatories, you still have that court officer who reads the questions to the witness and records the answers.
So one is more direct,
Yes,
and one's a little more formal.
exactly.
All right. Are there rules about timelines, like how quickly someone has to respond to these interrogatories?
Yeah, there are specific timeframes for when you can submit them
Okay.
and when the other party has to respond.
All right. And can you object to interrogatories just like you can with a deposition?
You can, yeah. If you feel there's improper, irrelevant, you can object.
So fairness is built in here as well.
It is.
You mentioned a case earlier that illustrates how interrogatories work in practice. Could you tell us a bit more about that?
Sure. The San Luis v. Rojas case is a good example. So basically, the plaintiff used interrogatories to force the defendant to reveal specific facts
Oh, wow.
that were really important to the lawsuit.
So it really helped them kind of move the case forward.
It did.
Right. So that's interrogatories. Let's move on to the next mode of discovery, which is requests for admission.
Okay.
It sounds like we're getting closer to really pinning down the facts of a case here.
Yeah, we are. Requests for admission, they're all about streamlining the process. So you're basically asking the other party
Okay.
to admit or deny specific facts
Uh-huh.
or the authenticity of certain documents. It helps narrow down the issues that are actually in dispute.
So it's like saying, hey, let's just agree on this stuff up front so we can focus on what we actually disagree on.
Exactly. It saves everyone time and energy.
Now, are there any specific rules about how these requests work?
Yeah, definitely. There are rules about, phrasing them,
Okay.
how the other party has to respond, and how long they have to respond. One interesting thing is the concept of implied admission.
Implied admission.
Yeah. So if a party doesn't respond to a request for admission within that given time frame,
Uh-huh.
it's considered that they've admitted to those facts.
Wow. So silence can be powerful
It can be.
in this legal game.
It can be.
Now, are there any cases that come to mind that show the nuances of this rule, how it works in practice?
Yeah, the Nestle Philippines Inc. v. CA case. It highlighted that a lawyer's signature
Yeah.
on a response to a request for admission, that's enough for compliance,
Interesting.
even if the client themselves didn't sign it.
So paying attention to the details is very important.
It is, yeah.
All right, so that's request for admission. Let's move on to a mode of discovery that, I don't know, it sounds like it's straight out of a detective movie.
Oh.
Production and inspection of documents and things.
So yeah, this is all about accessing the tangible evidence. So we're talking documents, contracts, physical objects, anything relevant to the case.
So this is where you actually get your hands on the proof.
Exactly. Think of it as like putting together a puzzle. You need all the pieces to see that full picture.
Now, I'm guessing, you can't just go barging into someone's office and demand to see everything.
No.
There have to be rules around this, right?
So yeah, the big thing here is good cause.
Good cause.
Yeah, you need a valid reason to request access to those documents.
Okay.
Plus, there are actually 6 conditions that must be met. So, number 1, it has to be filed as a motion. 2, notice has to be served to all parties. 3, the motion must designate the documents or things to be produced. 4, they have to be relevant. 5, they can't be privileged.
Okay.
And lastly, they have to be in the possession or control of the other party.
So a lot of safeguards in place
Yeah,
to make sure the process isn't abused.
exactly.
Now, I'm remembering you talked about another way to get documents, subpoena ducis tecum.
Yes.
How is that different from this request for production under Rule 27?
Good point. So a subpoena ducis tecum, you can get documents from anyone,
Oh,
even someone who's not involved in the lawsuit.
gotcha.
Whereas Rule 27 is really focused on getting documents or objects
Okay.
from the other party in the lawsuit as part of the discovery process.
So it's like using the right tool,
Yes.
the right job.
Exactly, yeah.
All right, let's talk about those situations where someone's physical or mental state is actually like a key issue in a case.
Sure.
I imagine that's pretty delicate, right?
It is, yeah. So that's where physical and mental examinations come in.
Okay.
These examinations, they're very sensitive. So they require what we call good cause and a court order.
So you can't just ask for one lightly.
No.
All right. Walk me through how this process actually works.
Okay, so let's say someone's injuries are a key issue in a personal injury lawsuit.
Okay.
The court might order them to undergo a physical exam by a doctor that was chosen by the other side.
All right.
After that examination, the person who is examined, they have a right to request a copy of the examiner's report.
So there's transparency built into the process.
Yes, there is.
Now, what happens if the examiner refuses to hand over that report? Are there any consequences for that?
Yeah, the court could actually decide to exclude that examiner's testimony
Oh, wow.
altogether if they refuse to provide the report.
Okay.
Transparency is key for ensuring fairness.
So you wouldn't want someone to base their case
Exactly.
on a report that the other side can't even see.
Right.
Okay, so we've talked about all these ways to gather information.
Yeah.
But what happens if someone just ignores the rules of discovery?
Well, there are consequences for not playing by the book.
Oh, there are.
Yeah. Rule 29 outlines different remedies that the court can use to enforce compliance.
So it's like the court's the referee.
Yeah, exactly. They're making sure that everyone follows the rules of the game.
All right. So we've got consequences for not following the rules. What kind of remedies are we talking about here?
So it can be pretty serious. Like if someone refuses to answer a question during a deposition,
Right.
the court could order them to answer it,
Oh, okay.
or even find them in contempt of court.
Wow, so there's some teeth to this.
Yeah.
And I guess in some cases, the court could even rule in favor of the other side
They could, yeah.
on that particular issue.
Yeah, just to ensure that,
Right.
everything's fair.
Fairness is really a theme here.
It is.
What about if someone, say, refuses to produce documents?
Right.
Or maybe they skip out on a court-ordered examination.
Those are big violations,
Right.
and there can be some pretty serious consequences.
Like what?
So the court, they might prevent that party from using certain evidence at trial.
Oh, wow.
They could even strike out parts of their pleadings. Okay.
Or, in some cases, they could even dismiss the case entirely.
Wow, so they're not messing around.
No, they're not.
All right, so we've covered all 5 modes of discovery.
We have.
Depositions, interrogatories, requests for admission,
Right.
production and inspection, and those physical and mental examinations.
Uh-huh.
Let's do a quick recap,
Okay.
just to make sure it's all crystal clear for everyone.
So good.
All right, so going back to that handy acronym, D in Repodec,
Yeah.
D for depositions. Those are like those mini trial
Uh-huh.
where you get that witness testimony under oath
Exactly.
For interrogatories,
Yes.
those are detailed questionnaires
Yeah.
to get those key facts directly from the other side,
Yep.
for requests for admission.
Uh-huh.
This is where we try to, pin down some of those undisputed facts,
Right.
narrow down what we actually need to argue about in court.
Exactly.
POCO for production and inspection.
Yes. This is where we get our hands on the documents, the objects,
The proof.
the proof. Yeah. And finally, debt for those physical and mental examinations.
Right.
For those specific situations where someone's health or mental state is a central issue.
Yep.
All right. I think we covered it all.
I think so.
These rules, they might seem a little technical at first,
They can, yeah.
but once you kind of understand the logic behind them, it really makes sense.
It does.
It's all about making sure everyone has a chance to present their case.
Absolutely.
And it's all done fairly.
Fairness, transparency,
Transparency.
making sure everything's above board.
Exactly. Well said.
Thank you.
So a huge thank you to our legal expert
Of course.
for walking us through these sometimes confusing rules of discovery.
My pleasure.
And of course, thank you to our amazing listeners
Yeah, thank you.
for joining us on this legal adventure.
Yeah.
We'll see you next time.
It really helps to think about it like, the court really wants to make sure that the whole process is fair and that it works,
Yeah, makes sense.
So they've got these different options that they can use to, deal with folks who aren't playing by the rules.
So the court has a lot of power to keep things on track, it sounds like.
They do. They do.
Now, we've talked about all 5 of those modes of discovery, right?
We have.
Depositions, interrogatories, requests for admission,
Yeah, right.
production and inspection, and then those physical and mental exams.
Yep.
Let's do like a super quick recap,
Okay, sure.
just to make sure it's all crystal clear,
Mm-hmm.
for everyone listening.
Sounds good.
All right, so going back to that acronym we talked about before, D in ROPODET.
Yes.
D is for depositions.
Right.
Those are like those mini trials we talked about,
Uh-huh.
where you get that witness testimony under oath.
Exactly.
Then we've got N for interrogatories.
Yes.
Those are the super detailed questionnaires that we can send
Right.
to get those key facts from the other side.
Yep.
Read requests for admission.
Uh-huh.
That's where we're really trying to narrow things down.
Exactly.
Pinpoint those facts that aren't in dispute.
Right.
Pull production and inspection.
Yep.
That's where we're actually getting our hands on, the documents, the objects.
That's right. All the evidence, all the proof.
Exactly the proof.
Uh-huh.
And then finally, debt for physical and mental examinations.
Yeah.
For those kind of unique situations where someone's health or their mental state is like a key part of the case.
Exactly.
All right, so I think we hit everything.
I think we got it all.
These rules, they might seem a little technical at first,
They can be. Yeah.
but once you understand the why behind them,
Mm-hmm.
it really clicks.
Yeah, it's all about making sure the process is fair.
Right, and making sure that everybody has that chance to present their case, effectively.
Absolutely.
Well said. I think that's a great way to put it.
Thank you.
So a huge thanks to our legal expert
Of course.
for breaking down all these rules of discovery for us.
Happy to do it.
And of course, to all of our wonderful listeners, thank you for joining us on this deep dive into the world of civil procedure.
Yes. Thank you for listening.
We'll see you next